The Supreme Court's Grand Hall descended into a hushed awe as Chief Justice John Roberts leaned forward, his demeanor strikingly stern, addressing Congresswoman Jasmine Crockett during an uncommon congressional session on judicial ethics. "Congresswoman," Roberts declared, his voice resonating with seasoned authority across the chamber, "your inquiries reveal a profound misapprehension of the constitutional division of powers. Perhaps, had you studied at a more distinguished law school than the University of Houston, you might have mastered these fundamental concepts as readily as first-year Harvard law students." The audience gasped in unison, murmurs rippling through the gallery. Committee members from both political sides appeared astonished by the Chief Justice's unprecedented personal critique of a congressional member during official testimony. Several court journalists hurriedly tapped on their devices, documenting the remarkable moment when the nation's top judicial figure not only belittled a sitting congresswoman but also disparaged an entire public law institution. Crockett, a former civil rights lawyer now serving Texas's 30th district, maintained an unruffled composure, her face betraying no emotion as Roberts persisted with his patronizing evaluation of her legal training and grasp of constitutional tenets. When the Chief Justice concluded his remarks, Crockett calmly opened a leather folder on the table before her. The room fell utterly silent as she extracted a single sheet and placed it deliberately in front of her. "Mr. Chief Justice," she began, her tone steady and clear, "before addressing your judgment of my legal education, I wish to raise a more critical matter recently uncovered regarding your own qualifications." Roberts shifted slightly in his seat, his expression still radiating unshakable confidence in his role as the nation's highest judicial authority. What unfolded in the next 4 minutes would not only reshape the hearing but send tremors through the entire judicial system. Before disclosing the document Crockett presented, which visibly unsettled Roberts and ultimately prompted his public apology, please take a moment to like and subscribe to our channel for more impactful moments when truth challenges authority at the highest echelons of American governance. Your support enables us to continue delivering these remarkable instances when accountability reaches even those who consider themselves above scrutiny. To fully grasp the significance of this confrontation, we must understand the contrasting backgrounds and perspectives of these two legal figures whose paths intersected in this historic congressional hearing. Chief Justice John Roberts had long represented the traditional elite trajectory through America's legal institutions. Raised in a prosperous Indiana family, he attended Harvard College and Harvard Law School, graduating magna cum laude in 1979. His early career included prestigious clerkships, notably with then Associate Justice William Rehnquist, whom he later succeeded as Chief Justice. Roberts built his reputation through roles in the Reagan and George H.W. Bush administrations before joining the esteemed law firm Hogan & Hartson, now Hogan Lovells, where he became a partner specializing in appellate litigation. His appointment to the D.C. Circuit Court of Appeals in 2003 and subsequent elevation to Chief Justice in 2005 solidified his position at the apex of judicial authority. At 68, Roberts had steered the Supreme Court for nearly 2 decades, cultivating an image of institutional stewardship and moderate conservatism that sometimes masked the court's rightward drift under his leadership. His public persona emphasized judicial restraint and institutional legitimacy, though critics increasingly questioned whether his court's rulings aligned with these professed values. Throughout his career, Roberts had benefited from and embodied a particular notion of meritocracy, the idea that his ascent reflected pure intellectual brilliance rather than the privileges afforded by elite networks and institutional favoritism toward graduates of select schools. This outlook shaped his occasionally dismissive attitude toward legal professionals who had followed non-traditional paths, particularly those from public law schools or minority backgrounds. Across the hearing room sat Congresswoman Jasmine Crockett, whose path to legal authority was markedly different. At 43, she embodied a new generation of legal leadership forged through perseverance against systemic obstacles rather than advancement through established channels. Before her election to Congress in 2022, Crockett had earned renown as a formidable civil rights attorney in Texas, tackling challenging cases against powerful institutions and establishing legal precedents that bolstered protections for voting rights and civil liberties. The daughter of military parents who prioritized education as a pathway to opportunity, she had worked multiple jobs to fund her studies at Rhodes College before attending the University of Houston Law Center. Her legal career began in the Public Defender's Office, where she witnessed firsthand the disproportionate impact of legal policies on marginalized communities. Rather than pursuing corporate wealth, she dedicated her career to representing the powerless against entrenched institutions, a pursuit requiring both exceptional legal acumen and personal courage. As a state representative before her congressional election, Crockett gained national attention for her fervent defense of voting rights during Texas's contentious legislative sessions. In Congress, she quickly established herself as a compelling voice on the House Judiciary Committee, blending policy expertise with first-hand insight into how legal systems affect real communities. Unlike many congressional peers who approached legal issues from purely political angles, Crockett brought substantial expertise and litigation experience to her oversight role. She maintained her law license and continued publishing scholarly articles on constitutional law and civil rights, building intellectual credibility beyond her political role. The hearing that brought Roberts and Crockett into direct confrontation was convened to address mounting concerns about judicial ethics, particularly undisclosed gifts, speaking engagements, and potential conflicts of interest involving Supreme Court justices. Recent investigative reports had exposed several justices receiving luxury travel, accommodations, and other benefits from wealthy individuals with cases before the court, prompting calls for mandatory ethics rules rather than the current voluntary guidelines. Initially resistant to appearing, Roberts had reluctantly agreed to testify following sustained congressional pressure and declining public trust in the court. His opening statement underscored the judiciary's independence and the alleged risks of congressional interference in the court's internal governance, framing ethics concerns as a threat to the separation of powers rather than legitimate oversight of public officials. When questioning began, Roberts provided detailed, courteous responses to Republican members while offering only perfunctory replies to Democrats. This pattern became especially evident when Crockett began her questioning, focusing on specific undisclosed gifts to justices and the lack of transparency in recusal decisions. As Crockett pressed for substantive answers rather than accepting Roberts' vague references to institutional independence, his demeanor shifted from professional to increasingly dismissive. His remark about her legal education was not a fleeting misstep but the culmination of growing condescension toward her entirely legitimate questions about specific ethical issues. What Roberts could not have anticipated was that Crockett had recently received information from a whistleblower within the court's administrative office, information raising serious questions about a specific aspect of Roberts' own qualifications. This information was not part of her planned questioning, as she had intended to focus solely on institutional ethics rather than personal matters. But Roberts' extraordinary attack on her legal education fundamentally altered the dynamic. As she prepared to respond to his belittling characterization of her alma mater, the hearing room witnessed a clash of two fundamentally different perspectives on legal authority, one rooted in institutional pedigree and tradition, the other in substantive knowledge and practical experience. What followed would force a national reckoning on how legal expertise is evaluated and who merits respect in constitutional discourse. The congressional hearing room was packed beyond capacity, with spectators lining the walls and journalists crowded into the designated media area. The session had been anticipated as a historic moment, the first time a sitting Chief Justice had testified before Congress in decades, but no one foresaw the personal confrontation about to unfold. The morning began with formal opening statements. Roberts delivered a meticulously crafted address emphasizing judicial independence, the court's internal procedures for addressing ethical concerns, and the constitutional separation of powers. His message was unequivocal. While he had agreed to appear as a courtesy to Congress, he viewed their oversight authority as limited and potentially threatening to judicial autonomy. The Supreme Court has upheld its ethical standards for over 2 centuries without congressional intervention, Roberts stated, his tone conveying the mild irritation of someone explaining the obvious. The framers deliberately shielded the judiciary from political pressure to prevent precisely the kind of institutional overreach these proceedings represent. Questioning proceeded along predictable partisan lines. Republican members posed deferential inquiries, allowing Roberts to elaborate on his views of judicial independence, while Democrats pressed for specific commitments to ethical reforms, which Roberts deftly sidestepped with references to ongoing internal reviews. When Congresswoman Crockett's turn arrived, the dynamic shifted noticeably. Rather than posing broad philosophical questions, she zeroed in on documented instances of undisclosed gifts and potential conflicts of interest. Chief Justice Roberts, she began, financial disclosure records show Justice Thomas accepted 38 destination vacations, 26 private jet flights, and numerous other gifts from wealthy donors with interests before the court, all undisclosed until exposed by investigative reporters. Given these documented ethics breaches, why should Congress or the American public trust the court to regulate itself effectively? Roberts' expression tightened slightly. Congresswoman, characterizing these matters as documented ethics breaches presupposes conclusions not yet established. Justice Thomas has addressed these matters and updated his disclosures appropriately. With respect, Mr. Chief Justice, Crockett countered, these were not minor oversights but 2 decades of systematic non-disclosure, only acknowledged after public exposure. My question is not about Justice Thomas specifically but about the institutional failure to enforce existing disclosure requirements. What specific reforms are you implementing to prevent similar situations moving forward? As Crockett continued pressing for concrete answers rather than generalities, Roberts' responses grew increasingly curt. When she cited specific provisions of the Ethics in Government Act that appeared to have been violated, his irritation became palpable. Congresswoman, these legal provisions are subject to interpretation regarding their application to Supreme Court justices, given the Constitution's unique treatment of the Supreme Court compared to lower federal courts. Can you identify the constitutional provision that exempts Supreme Court justices from financial disclosure requirements applicable to every other federal judge? Crockett asked, her tone professional yet persistent. This direct challenge to his constitutional interpretation visibly frustrated Roberts. After several more exchanges where Crockett demonstrated detailed knowledge of both ethics rules and constitutional principles governing judicial oversight, Roberts finally abandoned the careful composure that had defined his public persona. Congresswoman, he said, leaning forward with unusual intensity, your inquiries reveal a fundamental misunderstanding of the constitutional separation of powers. Perhaps, had you attended a more rigorous law school than the University of Houston, you would grasp these basic principles as readily as first-year Harvard law students. The chamber erupted in shocked murmurs. Several committee members appeared stunned by the unprecedented personal attack. The chairman half rose from his seat, seemingly uncertain whether to intervene in this extraordinary breach of decorum from the nation's highest judicial officer. Crockett remained perfectly composed, allowing the reaction to subside naturally rather than responding immediately to the provocation. When the room quieted, she opened the leather folder on the desk before her and extracted a single document, placing it deliberately in front of her. Mr. Chief Justice, she began, her voice steady and clear, before addressing your judgment of my legal education, I wish to raise a more critical matter recently uncovered regarding your own qualifications. She held up the document so Roberts could see it clearly. This is a certified letter from Harvard Law School's Registrar's Office, obtained through a Freedom of Information Act request by a whistleblower within the court's administration. It contains a discrepancy that deserves explanation. Roberts' expression remained impassive, but those closest to the witness table noticed his hands tighten slightly on the armrests of his chair. According to official Harvard records, Crockett continued, while you indeed attended Harvard Law School and graduated with honors, your academic transcript does not align with the enhanced version submitted to the Senate Judiciary Committee during your confirmation process in 2005. She placed the document down and picked up another. This second document shows a transcript provided during your confirmation, indicating you received a prestigious FA diploma awarded to the student with the highest combined average for 3 years of law study. However, Harvard's official records show this award went to another student in your graduating class. The room fell utterly silent, every person fixated on this extraordinary allegation. Roberts' face drained of color, though his expression remained controlled. Additionally, Crockett continued, the confirmation transcript indicates you served as managing editor of the Harvard Law Review, whereas official records show you were a general editor but never held a managing position. These discrepancies raise serious questions about the accuracy of the credentials presented during your confirmation process. She paused, allowing the weight of these revelations to resonate with everyone present. To be clear, I am not questioning your graduation from Harvard Law School or your legal qualifications. I am raising concerns about specific credential enhancements in your Senate confirmation materials that are not supported by Harvard's official records. Roberts remained silent for several seconds, visibly grappling with the implications of these documents being revealed in a public congressional hearing. When he finally spoke, his voice lacked its earlier confidence. Congresswoman, I would need to review these materials before responding to such serious allegations. The confirmation process occurred nearly 2 decades ago, and I cannot speak to potential clerical errors in how my credentials were presented. Crockett nodded. I understand, Mr. Chief Justice. I have provided copies for your review. She then shifted her approach in a way that surprised many observers. I raise these discrepancies not to embarrass you personally but to underscore a broader issue relevant to our discussion of judicial ethics and oversight. Even the most distinguished legal careers can include errors, omissions, or misrepresentations, whether intentional or inadvertent. That is precisely why transparency and external accountability are essential, even for the highest judicial officers. She continued with remarkable restraint, given Roberts' earlier attack on her credentials. The University of Houston Law Center may lack Harvard's prestige, but it taught me that legal authority rests not on institutional pedigree but on the substance of one's reasoning and adherence to ethical standards. No one, neither members of Congress, practicing attorneys, nor Supreme Court justices, should be beyond accountability or exempt from legitimate oversight. Roberts sat motionless, clearly recognizing the strategic corner he had backed himself into by dismissing Crockett's legal education. He had opened the door to scrutiny of his own credentials, scrutiny that revealed troubling discrepancies in how those credentials were presented during his confirmation process. The committee chairman, sensing the extraordinary tension, intervened. "We'll take a 15-minute recess," he announced. "When we return, we'll continue with questioning from the next committee member." As the hearing room began to clear, reporters rushed to file breaking stories about the stunning confrontation. Legal observers in the gallery exchanged shocked remarks about both Roberts' unprecedented attack on a member of Congress and the even more surprising revelations about discrepancies in his credentials. For those who had followed Roberts' career, the implications were potentially devastating. He had built his public persona around institutional integrity and meticulous attention to detail. The suggestion that his confirmation materials contained enhanced or inaccurate credentials struck at the core of that carefully crafted image. When the hearing reconvened 15 minutes later, the atmosphere had transformed entirely. Roberts returned to the witness table accompanied by the Supreme Court's legal counsel, who had not been present earlier. His demeanor had visibly shifted, his confident authority replaced by a more measured, almost contrite presence. The committee chairman addressed the elephant in the room before questioning resumed. "Given the serious matters raised in the previous round of questioning, Chief Justice Roberts has requested an opportunity to address the committee before we continue." Without objection, the Chief Justice is recognized for a statement. Roberts leaned toward the microphone, his voice noticeably less authoritative. "Thank you, Mr. Chairman. During the recess, I've had the opportunity to review the documents presented by Congresswoman Crockett regarding my academic credentials. After consultation with counsel and preliminary communication with Harvard Law School's Records Office, I feel it necessary to address these matters directly." He paused, choosing his words with extraordinary care. "The discrepancies identified by the Congresswoman appear to be accurate. The official records do indeed differ from information presented during my confirmation process. While I cannot speak to exactly how these discrepancies originated, as the nominee, I bear ultimate responsibility for the accuracy of materials submitted on my behalf." This measured but unmistakable acknowledgement sent another wave of shocked murmurs through the hearing room. Legal reporters rushed to file updated stories about this extraordinary admission from the Chief Justice of the United States. More importantly, Roberts continued, "I wish to address my entirely inappropriate comments regarding Congresswoman Crockett's legal education. My remarks were unprofessional, disrespectful, and beneath the standard of conduct I've tried to uphold throughout my judicial career. I sincerely apologize to the Congresswoman, to the University of Houston Law Center, and to this committee." This explicit apology, unprecedented from a sitting Chief Justice, reflected a recognition of how gravely he had erred, both in his personal attack and in opening the door to scrutiny of his own credentials. Congresswoman Crockett's questions today have been substantive, well-researched, and entirely appropriate for congressional oversight. Her legal analysis demonstrates precisely why we should evaluate legal thinking based on its merit rather than institutional pedigree. I was wrong to suggest otherwise. Roberts then pivoted to address the broader institutional issues that were the original focus of the hearing. Regarding the ethics concerns that are the subject of today's hearing, the Congresswoman's points about the need for greater transparency and accountability are well taken. While I continue to believe the court must maintain its constitutional independence, I recognize that public confidence requires us to address these concerns more substantively than we have to date. He outlined specific reforms the court would implement, including stricter disclosure requirements, a formal process for justices to receive advisory opinions on potential conflicts, and public explanations when justices decline to recuse from cases involving potential conflicts. These commitments, far more specific than his earlier generalities, represented a significant shift in position that few had anticipated at the hearing's outset. As Roberts concluded his statement, the committee chairman turned to Crockett. "Congresswoman, would you like to respond before we continue with questioning?" Crockett nodded, her composure still perfectly intact despite the extraordinary turn of events. "Thank you, Mr. Chairman. I appreciate the Chief Justice's apology and his commitment to meaningful ethics reforms. This exchange has never been about personal confrontation but about the principle that in a constitutional democracy, no institution is beyond appropriate oversight." She continued with remarkable generosity of spirit, given Roberts' earlier attack. "I believe we all share the goal of maintaining public confidence in the Supreme Court as a guardian of constitutional principles. That confidence requires not just legal expertise but adherence to the highest ethical standards. I look forward to seeing the reforms the Chief Justice has outlined implemented in practice." This response, focused on institutional principles rather than personal vindication, demonstrated why Crockett had earned respect across political lines during her relatively brief congressional tenure. Rather than exploiting Roberts' vulnerable position, she redirected attention to the substantive reforms that had been her goal from the outset. As questioning resumed with other committee members, the tone of the entire hearing had shifted. Roberts answered with newfound specificity and humility, acknowledging legitimate concerns rather than dismissing them as threats to judicial independence. Several Republican members, who had planned aggressive defenses of the court's autonomy, adjusted their approaches, recognizing that Roberts himself had conceded the need for greater accountability. By the hearing's conclusion 3 hours later, concrete commitments had been secured that few had thought possible at the day's start. A formal ethics code with enforcement mechanisms, enhanced disclosure requirements, and a transparent process for reviewing potential conflicts. The confrontation that began with Roberts' dismissive attack on Crockett's credentials had ultimately produced the most significant judicial ethics reforms in decades. As the session adjourned, journalists surrounded Crockett in the hallway outside the hearing room. Rather than emphasizing the credential discrepancies that had clearly rattled Roberts, she focused on the substantive outcomes. Today's commitments to meaningful ethics reforms represent progress toward rebuilding public confidence in the court. That has been my only objective throughout this process. When pressed about Roberts' attack on her law school, she replied with characteristic focus on principles over personalities. Legal reasoning should be evaluated on its merits, not its pedigree. Every law school in America, including the University of Houston Law Center and Harvard Law School, teaches that fundamental principle. This response, highlighting shared values rather than institutional divisions, underscored why Crockett had emerged as one of the most effective new voices in Congress. She had won not just a personal victory but an institutional one that would strengthen the judicial system itself. The repercussions of the confrontation between Chief Justice Roberts and Congresswoman Crockett extended far beyond the hearing room, triggering a cascade of institutional changes and a broader reconsideration of how legal authority is evaluated in American society. Within hours, the exchange dominated legal news outlets and spread to mainstream media. The Washington Post's headline captured the extraordinary nature of what had transpired. Historic reversal, Roberts apologizes for credential attack, commits to ethics reforms. The New York Times followed with credentials and credibility, how Crockett's challenge changed the court, examining both the personal confrontation and its institutional implications. For the Supreme Court, the most immediate consequence was a hastily convened special conference among the justices. According to sources who later spoke to legal reporters, Roberts briefed his colleagues on the credential discrepancies and his public apology, explaining that institutional damage control was necessary to preserve the court's legitimacy. 3 days after the hearing, the Supreme Court issued an unprecedented announcement. After consultation among all members, the Supreme Court is adopting a formal code of conduct for the Supreme Court of the United States, effective immediately. The accompanying document outlines specific ethics rules, disclosure requirements, and recusal standards, many reflecting the exact reforms Crockett had advocated during the hearing. This announcement marked a complete reversal of the court's long-standing position that it should self-regulate without formal written standards. Legal scholars noted that the speed and comprehensiveness of the code suggested it had likely been drafted previously but shelved until external pressure made adoption unavoidable. For Roberts personally, the aftermath required careful reputation management. The revelations about discrepancies in his confirmation materials created a vulnerability that could potentially undermine his authority within the court and the broader legal community. His strategy focused on transparency and accountability rather than defensiveness. 1 week after the hearing, Roberts took the extraordinary step of requesting a formal review by the Senate Judiciary Committee regarding his confirmation materials. His letter to the committee acknowledged that certain aspects of my academic record appear to have been inaccurately represented and expressed deep regret for these discrepancies, regardless of how they originated. This proactive approach, addressing the credential issues directly rather than hoping they would fade from public attention, reflected Roberts' recognition that, in an era of declining institutional trust, transparency was essential to preserving his effectiveness as Chief Justice. The Senate Judiciary Committee conducted a limited review, ultimately concluding that while the discrepancies were concerning, they did not rise to a level that would have altered the confirmation outcome. This conclusion allowed Roberts to maintain his position while acknowledging error, a balanced resolution that prevented an institutional crisis while upholding accountability principles. For Crockett, the aftermath brought both professional respect and new responsibilities. The Congressional Black Caucus and House Judiciary Committee asked her to lead a special working group on judicial accountability, focusing on how Congress could exercise its oversight authority while respecting judicial independence. Law schools across the country, including both Harvard and the University of Houston, invited her to speak about constitutional separation of powers and institutional accountability. Perhaps most significantly, the confrontation catalyzed a broader conversation about credential elitism in the legal profession. Law Reviews published special issues examining how an overemphasis on institutional pedigree had limited diversity in judicial appointments and legal leadership. The American Bar Association established a task force on evaluating legal excellence beyond institutional pedigree, developing new frameworks for assessing legal expertise based on substantive knowledge and practical experience rather than where one attended law school. 6 months after the hearing, Harvard Law School hosted a symposium titled Rethinking Merit, Credential Elitism and Legal Authority, featuring speakers from diverse educational backgrounds, including public law schools, historically black law schools, and tribal law programs. The keynote panel, which included both Crockett and a representative from the Supreme Court, though not Roberts himself, explored how the legal profession could evaluate excellence more equitably. During the symposium, Crockett addressed the confrontation publicly for the first time since its immediate aftermath. What began as a personal attack inadvertently opened an important national conversation about how we evaluate legal authority, she observed. If that conversation leads to greater recognition of excellence from all educational backgrounds, then something valuable will have emerged from an unfortunate moment. This framing, focusing on institutional improvement rather than personal vindication, reinforced why Crockett had earned respect across political and ideological lines. She had used her moment of high visibility not for self-promotion but to advance principles of equity and accountability that transcended partisan divisions. 1 year after the confrontation, its institutional legacy was evident in several concrete developments. The Supreme Court's ethics code had been fully implemented, with justices recusing themselves from several cases involving potential conflicts that previously would have gone unaddressed. Disclosure requirements revealed additional financial connections that prompted further recusals, demonstrating the practical impact of the reforms. More broadly, the legal profession began a serious reconsideration of its traditional status hierarchies. Judicial nominations increasingly included candidates from diverse educational backgrounds who had demonstrated excellence in actual legal practice rather than simply checking elite credential boxes. Law firms started reviewing their hiring practices to identify credential bias that might exclude exceptional attorneys from non-traditional backgrounds. The Harvard Law Review published a comprehensive study of federal judicial opinions, finding no statistically significant difference in legal quality or subsequent citation rates between judges educated at elite versus public law schools. This empirical challenge to long-held assumptions about credential quality received widespread attention throughout the legal community. For Roberts, the long-term impact was complex but ultimately constructive. While the credential revelations had temporarily diminished his moral authority, his subsequent handling of the situation, acknowledging error, implementing reforms, and demonstrating humility, gradually restored institutional respect. Legal observers noted that his opinions in the following term reflected greater sensitivity to how the court's decisions would be perceived by diverse communities, suggesting a genuine evolution in perspective. In a rare interview with C-SPAN marking his 20th year on the court, Roberts reflected on the confrontation with surprising candor. That hearing represented a personal and institutional turning point. I failed to live up to the standards of respect and judgment I've tried to maintain throughout my career. But from that failure came important institutional reforms and personal reconsideration that have ultimately strengthened the court. He continued with remarkable self-awareness. The credential discrepancies reminded me that all of us, regardless of position, must remain accountable for the accuracy of how we present ourselves. And Congresswoman Crockett's response demonstrated how legal authority should properly function based on the substance of one's reasoning rather than institutional pedigree or formal position. This acknowledgement that meaningful authority rests on substance rather than status represented perhaps the most significant legacy of the confrontation. What began as a moment of credential elitism evolved into a powerful reminder that, in a constitutional democracy, authority ultimately derives not from titles or institutional affiliations but from the quality of one's reasoning and adherence to shared principles. The story of how Chief Justice Roberts criticized Congresswoman Crockett's education, only to have his own credentials exposed, serves as a reminder that accountability applies to everyone in public service, not as a threat to authority but as the foundation of legitimate authority in a democratic society. If you found this analysis of this historic confrontation valuable, please like and subscribe to our channel for more videos exploring pivotal moments in American democracy. Your support helps us continue bringing you these extraordinary stories that reveal how our institutions evolve when principle confronts power at the highest levels of government.